Madam Chair, members of the committee, on behalf of the ACLU of Rhode Island, I'm here to express our strong support for this legislation. I think you've already heard lots of really compelling arguments. As the chair noted, right now the Supreme Court has clearly held that life without parole for juveniles is unconstitutional. The question is, at what point should juveniles serving less than life without parole be eligible to be heard and considered for parole? We think this is a very modest bill. All it says is that after 15 years that a juvenile has been sentenced to prison, they get to appear before the parole board. They let the parole board hear what they have to say. They let the parole board make a reasoned judgment, as they do all the time, as to whether parole is appropriate. It couldn't be simpler than that. It simply recognizes, as you've heard, juveniles are not the same as adults. They should not be punished the same as adults. They should be reconsidered after a reasonable period of time, and we certainly believe that 15 years is reasonable. There are many national organizations, including the American Probation and Parole Association, the American Correctional Association, that have also raised concerns about life sentences for juveniles. As you've heard, there are over 20 states in the country that have passed legislation like this, including a number of New England states. We hope that you will do the right thing as you did 2 years ago. You passed this bill out of committee and the floor. We hope you'll do it again this year, and I'll be glad to answer any questions. Thank
Steve,
you.
I just have one question. So this bill that we're talking about, it's referring to the original crime, right? So if the juvenile is incarcerated for a period of time and commits additional crimes while in jail, that may make he may get a sentence, or he or she may get a sentence for an additional crime that they would then have to answer for.
Yes.
And the reason why I say that is because this is, as one of the witnesses already stated, always associated with Craig Price, who couldn't keep himself out of trouble, and it was horrendous trouble, and it was, I mean, some of the most heinous things that he did in jail kept him there as well. But this bill would, what we're talking about here is that if a juvenile commits a crime as a juvenile and then is sentenced and doesn't do anything else within that 15-year period, he'd then be eligible for parole. But it wouldn't mean that they wouldn't be subject to additional charges or anything while in jail if they continued to commit crimes.
That's right. But I also want to just emphasize, I can't emphasize enough, this is solely eligibility. It never guarantees anything, regardless of what they've done afterwards.
Thank you. Any other questions for Mr. Brown? Senator Epcot.
Steve, do you think the system is flawed for putting these youngsters in jail and giving them a life sentence with parole, which is 25 years? Because I want to make sure that we're not sending under 18 years old and violating the Supreme Court, that we do have a statute. Or I'm trying to read this bill. I'm not sure if it's line number 29, page 2 that I'm missing. Is there a provision in here that bars the state of Rhode Island from sentencing anyone under 18 years of age life without parole? Are we correcting it in this bill? And if you're telling me the Supreme Court has ruled it unconstitutional, then we should make sure that we're not doing that.
Yes, I read the bill as allowing any sentenced to the ACI to be eligible for parole after 15 years.
After 15.
Yes.
But also repealing the statute, if it's under that section, that we should not be allowing an individual under 18 years old to be sentenced to life without parole.
Well, again, the U.S. Supreme Court has said that. So it would be improper for a sentencing judge to, at this point, to sentence any juvenile to life without parole. Should we correct it? Is there language
in the statute that we should be eliminating it? Because before you get to step 2, you got to eliminate step 1.
If Mr. Brown, if I can answer that, Senator, reading the part that's added, page 2, line 29 through line 33, it makes it very clear. Line 29, that the prisoner is sentenced and eligible for parole prior to the 15 years, they're going to be eligible at 15 years. The face of the statute is very clear.
At 15 years. And Steve, do you think the system right now, earlier I said there's a process, do you think we should also examine the process of those youngsters that are under 18 years old that commit a crime, the guidelines that we have created under Craig Price, should they be reviewed?
Yes, I think it would be appropriate to review them
And we should
in a
also,
different legislation, but yes.
okay, and review it with probably the judicial system to find out what happened here, if there's an
Sure.
issue.
I mean, I think there are lots of stakeholders who would be involved, but I think it would be appropriate to do that. One other quick thing, I am not certain about this, but I believe the reference on line 29 to 12-19.2 might be the life without parole statute. I'm not certain about that, but it would be easy to check.
Thank you.
Senator McKenna.
Mr. Brown, didn't the Supreme Court indicate that there may still be Didn't the Supreme Court indicate, Mr. Brown, that there may still be some rare cases where the crime is so heinous that there could be a sentence of life without parole that would not be unconstitutional?
There is some language in the original decision that suggested that, but all the decisions from the lower courts have essentially said, that circumstance is hard to imagine in light of the findings that the court made as to why it would be inappropriate to have a juvenile life sentence without parole in the first place.
See,
Senator McKinney.
I come from Buttonwoods, where Craig Price did what he did to a young mother and two little girls. So I can envision a circumstance that is so heinous that it might fit that rarest of circumstances. And it does seem to me that to simply state that regardless of the severity, it's always going. We've got to make it 15 years because that's in line with the Supreme Court. Seems to overlook the fact that they left a very slight opening, but they certainly seem to in Miller, which I think is the 2016 case, provide that slight opening for the cases that are most egregious and heinous.
Well, again, I will only emphasize again, all this bill does is talk about eligibility. Nobody qualifies for release, and that's the key part of this bill.
Thank you. Any other questions or comments for Mr. Brown? Thank you.